warm welcome introduction. Myself, James Van and Casio, we are from South Florida. Actually, it's our main office in Tallahassee, but we are from South Florida in Fort Lauderdale office. This is our first time being here, but hopefully won't be our last. All right, so good afternoon and welcome to our presentation on condominium association responsibility. So please note the division jurisdiction prior to developer turnover. The division might enforce and ensure compliance with Chapter 718 and the rules relating to the development, construction, sale, lease, ownership, operation, and management of residential condominium unit, and complaint relate to the procedural completion of milestone inspection under Chapter 553, Section 899. So what is our jurisdiction is? So note that after the turnover in the residential condominium is limited to, our jurisdiction is limited to election. So anything is including integrity, notice, and operation of an election. Financial issue relating to operating budget, reserve schedule, financial record, and notice of meetings for budget and other financial related meetings. For the maintenance record and unit access to association record under Chapter 718, Section 111, subsection 12, and the procedural completion of structural integrity reserve study under Chapter 718, Section 112, subsection 2G. So let's go over the course overview. So today we're gonna have three bullet points: power and duty of the board, association responsibility, and additional thing to know. So we will provide you with all the things you should know. The Board of Administration. What is a board? So everybody knows the board, right? And then their responsibility and their fiduciary duty is, right? Pretty much, some of you are on the board, correct? Yes. And so the Board of Administration or board are the elected or appoint. You could be elected or appoint board of director or other representative body which is responsible for the administration of the association. So let's go over the association power and duty. The association power and duty include those in the law governing corporation and those power and duty provided in the Condominium Act, which is Chapter 718. However, boards should also be aware of the following that may apply, although division does not have the authority to enforce Chapter 607, that's related to corporation, Chapter 617, corporation for non-profit, and Chapter 720, which is HOA. We have, wherever we go for the expo, we have a lot of questions regarding HOA. And as you all know, no agency in the state of Florida regulate HOA. So but hopefully in the future, I know that in the future, probably come in July, probably DBPR may take some of that responsibility. Well, that in the making, not anything in the law So the association may enter into, this is association power and duty continue. So association may enter into contract, sue, or be sued on behalf of all unit owners concerning matter of common elements to most or all unit owners. The association has the power to make and collect assessment, lease common elements, maintain common elements, repair, replace common elements, or association property. Real property and personal property for the use of benefit of the members. The association has the authority to purchase any land or recreation lease upon approval of the voting interest as required by the declaration. If no provision for approving is included, the declaration, then the required approval is needed to amend the declaration.
When do you have questions?
Yes, can you try to, yes, what's your question?
In what case would you lease a common element?
An extra
For
parking
the-
space.
Maybe for your birthday party?
Oh. Oh, so we can charge for common element.
If you
Oh,
have,
yes.
if you have a clubhouse or something
Yeah,
like
if you have
that.
a
I don't
clubhouse.
think it's in your, I think it's against your bylaws, to be honest.
Thank you.
Come to insurance. An association must use its best effort to obtain and maintain insurance to protect the association, property, and common elements. An association must obtain and maintain insurance or fidelity bonding to cover all persons who control or disburse funds of the association. The policy of bond must cover the maximum funds that will be in the custody of the association or its management agent at any one time. An association may also obtain insurance for the benefit of the association employees and the flood insurance for common elements. That the flood insurance is optional. Purchase of unit. Unless prohibited by the document, the association have the power to purchase unit and acquire, hold, lease, mortgage, and convey them. The association has the right to purchase units as a foreclosure sale for unpaid assessment or to take title in lieu of foreclosure. It is prohibited for a board member, manager, or management company to purchase a unit at a foreclosure sale resulting from the association foreclosure on its lien for unpaid assessment or take title by deed in lieu of foreclosure. And next is enter into unit. The board might have access to each unit during reasonable hours to protect the common elements or other units. This may be required when the maintenance, repair, or replacement of any common elements needed to be completed. So any question on that?
Yes.
Well, the previous,
Yes.
Is it in the statutes when, in the absence of the unit owner, we can go in because of certain issues that may occur? Is that in 718? In other words, if there's fire, flood, we see this, but nobody's there, and we need to get in, and
I
we
know
don't
what
have
the
to.
certain issues are.
Unless there's an emergency,
That's what I'm
then
talking about.
yes, then the board may enter the unit. Yes.
Okay.
Okay.
There is also, if you're trying to enter the unit and, not for an emergency, but they're not responding, you put notice on their doors. The statute also has a procedure for
typically we have a lot of empty units when we have the exterminator go around. And so there's always two of us, the exterminator and somebody else, so there's never one person. And we have like a standing approval from the unit owners, unless there are those couple that don't want us in there. But I was more concerned with emergencies and how the DBPR, you know.
There is a statute in there for emergencies.
Okay.
You are allowed.
Yes.
On the previous page, to get into rights of first refusal for the board, the association can buy rights of first refusal.
Right, first refusal.
Yeah, so that's something that, it's in your bylaws, the association
It is.
has the power to do that.
Yes.
So it would be perfectly fine
Yeah.
if they do.
So what this is saying though is that if we lien and foreclose for whatever reason, we can't then turn around and buy it.
Correct.
Individually, no.
Individually.
The association.
Unless,
Association.
yeah, individually. You also might not be able to buy it if there's something in your bylaws that prohibits the association
No,
from
that's a
owning
conflict of interest.
units.
Oh,
Yeah, it has the right to buy.
okay, the association.
Yes, the association has the right to purchase the land, the individual board member, manager, or management. Yes, sir.
Yeah, on the purchase of a unit, so does the unit owner that's living there have the right to purchase that unit? That goes up on a board when it goes up for sale. So does a unit owner have the right to purchase that at that price that they're putting up on the board over the purchaser?
So Cindy says,
Yeah.
Yes.
If they're a unit, as long as they're not a board member.
So when you're saying the association, the association has the authority to buy that unit, you're talking about every person that's living there has a chance to buy that unit if they want.
Correct.
If it's in your
they
documents.
put it up
It's
for.
gotta be
If
in
it's
your
in the
documents.
document. No.
All right, thank you for your question. Let's move on. Maintenance, common element. It is the responsible of the association to maintain the common elements: lawn, sidewalk, playground, gym, and pool. The declaration may state that limited common elements are only to be maintained by those entitled to use them. Alteration. If the declaration does not specify a process, 75% of the total voting interest of the association must approve the alteration or addition before material alteration or addition are commenced. So make sure that's 75%, 2/3 of the total voting right.
75% is 3/4.
Yeah, 3/4, yes, 2/3. Yes, sir?
Okay, getting back to the common elements. If you got a blockage in your sewer line, and it's 60 feet away from the building, who's responsible for that, the association or the common elements?
Good question. Check, first thing first, check your bylaw, see what's your governing document say.
Well, it doesn't say nothing about
I
that.
didn't say anything about that.
So
We had a blockage and our association was responsible for the expense of it.
where was the blockage? How far away
It
from the building?
was before the village property line and the water company.
All right, so you know.
So it was a good,
You know the property
it was a
owner.
good 60 feet out.
Yeah. No, the
You
reason
know.
I ask that, because a lot of times you bring that up front to them down there, and they'll tell you that you're responsible, and you're really not, and people just go about, they fluff it off, they think they're responsible. You want to know for sure, you know?
Usually,
No,
So
we had-
basically,
we
you're gonna
had
go look at the property line and see
We
where.
had Seacrest, we had Yuko, and we had the water department now.
Okay.
And it was now a property line, so our association had to pay the bill.
So
It was because
contact
somebody clogged it with,
so
baby
contact
wipes
the
or
Palm
whatever.
Beach water first, and then go
it
from
was
there.
both.
okay, thank you. Let's move on. Fine or suspension. An association has the power to levy reasonable fine and or suspend the use of common area or facility due to failure of a unit owner, its occupant or licensee or invitee, not complying with any provision of the declaration, the association bylaw, or the reasonable rule of the association, or if the owner is delinquent in any monetary obligation. To impose a fine or suspend use right due to non-compliance with the governing documents require a committee of at least 3 people who are impartial to the board. This cannot be board member, officer, employees, or their relative for those category. And a 14-day notice of an opportunity for hearing must be sent to the person in question. After the hearing, the committee approve or deny a fine or suspension imposed by the association by majority vote. The board cannot reverse this decision. So no fine with a single notice may exceed $100 per violation, and it shall not in aggregate exceed $1,000. No fine will become a lien against a unit. Suspension of unit owner use. To impose suspension of use right due to monetary obligation over 90-day delinquent. A hearing or notice is not required. However, this must be approved at a property notice board meeting. Gotta be 48 hours for board meeting notice. Monetary obligation include any fees, assessment or fines. Suspension of use right may be placed against the unit owner, tenant, licensee, or guest. Upon approval, the association must notify the unit owner and, if applicable, the unit occupant, licensee, or invitee by mail or hand delivery. Suspension cannot be placed on limited common elements used by the unit or any common elements needed to access to unit. Example like elevators, stairwells, parking lot, etc.
That they can be suspended from using those?
No,
No,
They
don't.
cannot.
They cannot.
Yeah.
They cannot lock you out. You cannot. You can use the elevator. You can use the stairwell. You can use the parking lot.
What
Yes.
about the unit?
You can't prevent them from accessing their unit, so.
Like the laundry room?
But you can take away their gate access?
As long as they can get in through the guest
The-
side of the
right.
gate. and,
You're not doing that.
That's up for
And what
legal,
about
but I
pool?
have seen that.
What about pools?
Yeah, we can call the law enforcement to do that. Yes.
So I have a question, so you saying if they're delinquent over 90 days, you can fine them something other than this late fee that might be in your documents? Or if you don't have a late fee in your documents, you don't need a fining committee to approve that fine?
It's to approve the suspension. The suspension has to be over 90
Oh,
days.
just for the suspension?
Yeah, and that can be for fines, fees, assessments, anything monetary.
I see, oh, that's the I see what you're saying. That's the reason for it.
Yes.
What is a notice board meeting? Is that the bulletin board, or do I have to email around the globe?
You just have to post it.
You can post it. You have to post it conspicuously on your bulletin board.
For
Good.
48 hours.
Yeah, for 48 hours.
I mean, we got people in Guatemala and Turkey and New York.
So
They
the,
have an email
so,
address.
yeah, if they
One button.
consented to receive notice, via email, that's when you would have to send out those notices via email. But if no one has consented, or those people haven't consented, you don't need to send that out. The only board meetings that you need to notice is the budget meeting, the annual meeting,
Yeah.
and any special meeting of the board.
Yeah.
Other than that, all board meetings are 48-hour notices that have to be conspicuously posted on unless they signed up for email notification, then you also have to send those email notifications.
Thank you.
We can move on.
Suspension of voting rights. An association may suspend the voting right of unit or member due to non-payment of any monetary obligation over the amount of $1,000 due to the association, and which is also more than 90 days delinquent. To suspend voting right, the association must provide proof of such obligation to the unit owner or member 30 days before the suspension take effect. The board approved the voting right to suspend at a properly called board meeting at least 48 hours notice after the imposition of the voting suspension. The board must notify the unit owner and, if applicable, the unit occupant, licensee, or invitee by mail or hand delivery. When an owner or member voting right have been suspended, the total number of voting interests of the association must be reduced by the number of suspended voting interests when calculating the total percentage or number of all voting interests available to take or approve any action. So example, if your association has 100 units and there are 20 units suspended from the voting, then 80 is the new total of eligible votes. Action, right to collect from the tenant. If a unit is occupied by a tenant and the unit owner is delinquent, the association may make a written demand that the tenant pay the obligation due directly to the association. The association must provide the tenant statutory notice by hand delivery or mail in a specific format when requesting rent. After receiving the association notice, the tenant is not liable to owner, landlord for any rent paid to the association instead of the owner. The tenant payment to the association begin after receiving a notice beginning the following month after notice sent. The tenant must pay the association until all monetary obligation of the owner have been paid in full to the association or until the tenant vacate the unit.
And that's only when the owner is 90 days? At what point does that come to play?
Probably think it's 90 days, but I would have to look that up for you. I'm not too sure on that.
Yeah. See, I see the statute didn't mention about that, so.
Didn't they say 1,000 or 90, I mean, wasn't it? So wouldn't it depend on?
That was for suspending.
I would love to have the answer to that question.
Yes.
So
So we
I
will.
read this in the bylaws, but I don't remember the time
I
frame.
know, for some reason I'm thinking it is 90 days in our bylaws, but I'm not 100% sure.
So we're gonna get your information later, and then we can email you the answer. We'll look it up for the answer. Thank you. Meeting notice. The association must remember unit owners have certain rights. Therefore, it is the responsibility of the association to know what those rights are. Since unit owners have the right to meeting, association must provide at least 48-hour notice of board and committee meetings, which must be posted conspicuously on the association property. Notice of the annual meeting and any meeting at which the board will vote on special assessment or make change through rule concerning unit must be mailed, delivered electronically transmitted to unit owners and also post on the condominium property at least 14 continuous days in advance of the meeting. Notice of any meeting which regular or special assessment against a unit owner are to be considered must specifically state the assessment that are to be considered and provide the estimate cost and description of the purpose for such assessment. 14-day notice. So for the special assessment, 3 things have to happen, right? The notice gotta be 14 days, the estimate cost, and the description of the purpose. So I know there's a lot of association have received a lot of special assessment meeting. Yes?
Definition of special assessment, is that something above and beyond maintenance of the building?
Yes.
Correct.
Okay.
Like the new service requirements,
Your group.
new roof and things like that. Now, we do have
Wait a minute,
jurisdiction,
new roof?
Well,
so,
if you're doing a special
If they're doing a special
You
assessment.
don't have reserves to pay
yeah,
for.
you don't have the
There is a
reserve.
lot to pay for.
Yeah, if you can't afford it. you
Yeah,
need
If your reserve is not meet the payment, then you need to call the special assessment to add more fund.
And I just wanted to mention, I think I mentioned it at one of our meetings, we just had a special assessment for the concrete, and I had Becker prepare the meeting notice and everything, and they did not charge us. And they will
Full
also,
chair.
and they will also do your annual they don't mail it for you, but they will prepare it.
Right.
And they
Yes,
will do this.
they do that.
Right, but they did that even for the special assessment for free. I know they do it for the annual meeting, and I'm like, well, why not have the lawyer do it? That just makes good sense.
If you're a client. pay
Well,
them.
we are a client.
You pay them for your-
Okay, and let's move on to the election notice. You can know the election is noticed. There's the first one and the second one, all right? 60 days and 14 days. The first notice of an election is always have to be sent out, mail, hand delivered, or electronically transmitted to unit owner at least 60 days before the date of the election. And the second notice of an election must be mailed, hand delivered, or electronically transmitted to unit owner no more than 34 days, but no less than 14 days before the day of election. For those of you who are on the board member, just keep that in mind, 60 days and 14 days. We receive a lot of complaint about. I haven't received the notice for the election, either the first notice or the second notice, so keep that in mind. Yes, when it comes to the election. Unit owner letter of inquiry. If a unit owner submit a written inquiry by certified mail to the association, it is the responsibility of the board to provide the unit owner with a written response within 30 days of receipt of the written inquiry. This is to either give a substantive response to the unit owner or to notify the unit owner that legal opinion has been requested or the advice from the division has been requested. So if the board decides that the response to the inquiry warrants a legal opinion, then the board has 60 days to provide substantive written response to the unit owner. If the response warrants the association to seek advice from the division, then the association must provide their response to the unit owner within 10 days after receiving the advice from the division. So just keep in mind, remember the rule 30, 60, 10, right?
I will say, so on that 30th day, they may send you their response and said, well, we're seeking legal counsel. So it does extend 60 days. So it will can be up to 90 days. Yeah, so
You can milk it.
I will say that.
Yeah, they might build the clock.
event that you receive an inquiry, you can respond at that point by saying we're seeking a legal opinion on this matter, and then that will, within 30 days, and then that will buy you additional 60 to seek your opinion from counsel and then ultimately respond with your counsel's advice?
Correct. As long as you respond within those 30 days, that you're seeking legal counsel, and then after that response, there's the 60 days.
So counsel,
that day.
like,
From
yes, from that day. So counsel might say that you might want to wait until the day of 29 to send out the letter that we are seeking legal counsel.
That's a postmark date of 30 days, and do you have to respond?
Yes, yes,
Respond
yes, the
certified
postmark,
mail as
yeah.
well?
Yeah, it starts when you receive the written inquiry. I will say we don't have jurisdiction on this, so unfortunately, if a complaint comes in, we can't investigate.
Yes, sir.
But that is there for any legal movement, if anyone wants to move forward.
And those inquiries can only be delivered via certified mail. If you have email or people have signed up to receive electronic notice, does that also impact, if the board receives it, that they have to respond to email, or is it only certified mail?
I think it's certified mail because sometimes the board don't have to respond to you by email. Yeah, so better be certified mail so you have the postmark. And you receive, acknowledge receipt.
So for written inquiries, it is certified mail. That's what it says in the statute. For access, like records requests, it does say a written request, so that can technically be email. But if the association doesn't open the email, doesn't choose to respond, there's no proof there that it was received. So it does. So when it comes to records, it is written requests. But here,
And it
this
must
one-
be certified mail?
not for records requests. We do suggest certify, that way you have proof. You can always go down and.
So if somebody gives us a letter asking for something, it doesn't have to be certified.
It doesn't have to be certified. If you acknowledge that letter, now you can make reasonable rules as an association. Now it would be.
You would have an issue with that,
What about certificate of mailing, which is considerably less expensive than certified? It's the old term was franking, and it was just a way
So-
to, you go to the post office, you fill out a little slip, and they say, yes, this was mailed to this address on this date.
For records access, that would be fine, as long as, it shows your receipt, but for inquiries, it would be
Right.
certified.
I thought a records request
Records.
really only had to be responded to if it was received by certified mail. I thought that's the way the statute.
Statute doesn't say certified, it says written request. Receive a written
But you
request.
must respond if the request was certified. It doesn't say you have, I'm gonna double check that.
Yeah,
but that's always
so-
what I request.
Like I said, the association can make reasonable rules on the type of request. So if that's a reasonable rule, if it's reasonable or not, then it's legal to decide.
And I have another question. Do you have to offer people the option to get electronic communications?
You have to get a signature with a form.
Correct, but do
You
you
don't-
have to offer it,
you
is
don't
what I'm
have to.
saying?
There's nothing that says you have to.
Good, because I think I'm gonna be saying.
Thank you.
Did I hear you say
Back.
that, you have no jurisdiction over this? Who's the division then?
No division. So this would be something that you would have to take it upon yourself to go at them legally, their failure to respond to your inquiry.
You're not the division mentioned there?
We're in the division, but we don't have jurisdiction on it. But this is in the statute, so we're just giving you information in the statute of what's
I
there.
saw it because I thought I learned when they were reviewing this new law, that you were going to have jurisdiction.
So
over
because
this.
it hasn't passed yet, I can't say.
Oh, July.
He's coming back.
Yes,
Correct.
ma'am.
Yeah, I will say,
Gotcha,
if you want to see House Bill 1020 is the new law.
House
if
Bill
you have-
1021.
1021. If that's what passes, you'll see what.
You might want to read into it. There's some change, but it's not official yet, so until July 1st. So
Gotcha.
we're in the process of
That's why this is.
make some change. with the new regulations. And we're gonna be expanding a little more. Yes, so we can expect.
So to finish up with that question, we must respond in 10 days. If it is our intention to turn the inquiry over to the division, well then how much time then does the division have to respond if you have no jurisdiction? And at what point do we finally tell the unit owner, you're out of luck?
So internally, our response time is 48 hours when it comes to inquiry. So you should be getting a response in 48 hours after it's assigned to someone.
Which can theoretically be we have no jurisdiction to
Which
figure out.
it might be in a week when it comes to inquiry. So.
Yeah, but it says from the time that we receive advice from the division.
Yeah, so when you get a
10 days after.
response.
Right, it's when you get the response.
It's 10 days after we get the response from the division.
Sometimes we get inquiry that's non-jurisdiction, then we probably give you some information, some source that you can go look for advice. Or, I know that could be hectic. Yes, ma'am.
So what is your email for questions? Presumably not that one.
CTMH education.
Yeah,
My
we'll have it
fault.
on the screen at the end.
Yes, at the
Oh,
end.
good.
We have our information at the end. So you can email directly to Castle Marquez or James Van. Any one of us can answer your question. Yeah. Or our team with Shayna, Anna. Yeah. All right, new requirements. Florida legislature enacts new requirements for structural inspection for all buildings that are 3-story or higher. Therefore, it is the association responsibility and obligation to fulfill this requirement. So this can be big because there's a requirement for the 3-story or higher to report your building, and plus with doing the milestone inspection and then the reserve stuff. So it's a lot going on. So that's why there's a call for special assessment. Yeah. Association. What are association responsibility? The association is responsible for all costs associated with milestone inspection. The association must notify unit owner within 14 days after receipt of a written notice that a milestone inspection is required, and provide the date the inspection must be completed. The association must distribute a copy of the inspector prepared summary report to each unit owner by mail or personal delivery within 45 days after receiving a phase 1 or 2 milestone inspection. So what is phase 1 and phase 2? So usually phase 1 is visual inspection and phase 2 is detailed inspection. And I think it's a lot of, I don't know how the engineer and architect people do it, but most of the building pass up phase 1. Doesn't have to go through phase 2. So phase 2 is going to be more expensive. Yes?
The milestone inspections, are those for all buildings?
No.
Only for the
Only for the building 3-story or higher in height. And it's determined by the Florida Building Code. So if you don't know if your building is 3-story or higher, check with maybe your local building report.
Okay.
Yeah, to make sure. And and then me and Castle the other day we go back into the statute and find exactly what is the definition of 3-story, or how high from the floor up, from the ground up. They don't know exactly. So
30 feet, roughly?
yeah, they don't give that precise number. So 3-story or higher. So what if they have some of the building, they probably have a half basement or something like that. You never know. Yes, true. Yes. There's some old condominium, yeah. Some building, yeah. Yes, I know. Yes. So that will be determined by the floor building code. So good thing is DBPR don't have to determine, come out and have a ruler, or we have to measure. The association must post summary report in a conspicuously placed on the condominium property and on the website if there's one. And talk about the website, we're gonna go over detail later. Come July 1st, it's no longer 150, but it's 25 or more unit required website. That's more money there, right there. Milestone inspection become part of the official record and must maintain for 15 years. And come the structural integrity reserve study. When does a residential condo must have structural integrity reserve study completed? At least every 10 years after the condo creation. For each building that is 3-story or higher in height, determined by Florida Building Code, study of A item must be completed as is related to the structural integrity and safety of the building. The search become part of official record and must maintain for 15 years. So you know all the A item, right? What are structural integrity reserve study requirements? Identify each item of condo property being visually inspected. State the estimate remaining useful life. Estimate replacement costs and defer maintenance expense for each item. Provide a reserve funding schedule with a recommended annual reserve amount. So who can perform search? Any person qualified to perform the visual inspection. It can be engineer, licensed under Florida Statute Chapter 471, an architect, licensed under Florida Statute Chapter 481, or a person certified as reserve specialist by CAI. CAI stands for Community Association Institute Reserve Study Standard, or Professional Reserve Analyst by APRA, which stands for Association of Professional Reserve Analysts. Which association that must obtain a cert? Back to a lady question. All associations that have building of 3-story or higher in height and budget adopt on or after December 31st, 2024, except multi-condominiums operating at least 25 condominiums. Which association is not subject to search? Any association are 2-story or less. The unit owner may waive, reduce, or use reserve for other purpose if approved by majority vote of the total voting interest of the association. What is the majority vote? If there are 50 units in your association, the majority number is 26, right? 50% plus 1. Yeah, we have break time.
Sorry.
No problem. Search exemption. Florida law exempts the following from the search requirement. Building less than 3-story in height. Single family, 2-family, or 3-family dwelling with 3 or fewer habitable story above ground. any portion or component of a building that has not been submitted to the condominium or cooperative form of ownership. Any portion or component of building that is maintained by party other than the condominium or cooperative association. Come fun time, official record. We got the most complaint about this, right? Castle? So please keep this in mind. What are official records and how long should record be kept in Florida? Condo associations are required to maintain the following document permanently. So forever, example, plans, permit, and warranty from the developer. Article of incorporation, declaration, bylaws, current rules, and minutes of all meetings. So make sure the minutes too, this can be forever. Right, every minute of meetings.
Correct, so minutes were not forever. So minutes before had to be kept for 7 years. So when that came into statute was 2018, so you do need at least minutes from 2011. Because that would be 7 years back. But anything before 2011 is realistically not expected.
So we don't have anything back more than 5 or 6 years ago before we took over. They just had no records.
Correct.
Yeah.
I will say,
But we documented that
Yeah.
and signed off on it so that it's,
as long as there's no complaint towards that, then that's the investigators.
we
to
have
figure
no
out.
idea, none of us living there, so.
But, if anyone has records, just letting them, we expect it to be from 2011.
There might be one
From-
owner that has records, just refuses to admit it.
Yeah.
And so it's from probably in the future they do have a record digitized, so that'd be better, so we can keep it longer. For 15 years, milestone inspection and structural integrity research study. For 7 years, all other official record, roster of all unit owners, all current insurance policy, accounting records. And for 1 year, election records such as ballots, sign-in sheet, voting proxy, electronic records, and bids after receipt must be maintained for 1 year. And who can inspect official record? So who can request access? Unit owners and any person authorized by an association member can request access to official record without stating a reason or purpose for the inspection at all reasonable time. Unit owner need to submit a written request to the association via certified mail or hand delivered with a acknowledged receipt, right? Upon receipt of a written request, association has 10 working days to comply with such request. So only a working day count, minus the weekend. So no Saturday and Sunday.
Are there any records that would not be proper to show or expose?
Yeah. We have a slide for that? Record.
No, we don't have this slide.
So records that are not allowed to be shown, medical records, licenses, account numbers, anything legal that you got going on at the moment, employee agreements, compensation, anything like that. They can't see the management agreement, but they can't see how much you're paying the employees and things like that.
And what about background credit checks on
You
it?
cannot know.
Okay.
Oh, thank you. Because real estate chasing me for records, no.
No, yes,
Yeah.
no, you
You
cannot
can't share
disclose that.
delinquency information for other owners.
Yeah, so delinquency, again, you can check all the accounting records. Any unit owner can look up any other person's unit owner
emotional support animals, they can't see the letters from the doctor regarding that, because it's considered a HIPAA.
Personal.
James?
Yes.
Question there.
That also includes any legal communications that would be privileged, correct?
Yes, yes, correct.
Question?
Yes.
I'm just wondering, most of our board is gone for the whole, once we're out of season. How would they answer? How would they get back to you within 10 days?
So
We
most,
have a board of 20 people.
so most of them are away on the business trip.
No, and they're gone back to their
Seasonal.
Seasonal.
So
Yeah.
it's their responsibility to.
They must?
They must, yeah. So if
The
we-
property
And if
manager
they
can
don't,
give
what
out.
is
Oh,
the,
after
Correct.
July?
They have a fiduciary.
The property manager, that's in their contract there.
so somebody
You
from
can
Seacrest
request,
would
right,
have
you can
to.
request through the property manager.
And if they don't?
If they don't provide you the access, you can file a complaint with the division. for that. You can file
Who is
against the
the
property
division?
manager, DBPR. You can file against the property manager or against the board itself, whichever you.
Thank you.
And after
Yes.
July 1st.
How to obtain copy of official record. Unit owners can use portable device for free of charge, such as smartphone, camera, scanner. So if unit owners want the association to provide copy of request records, there will be a reasonable fee applied for each such service. Only reasonable, right? Not, you're not gonna charge, your board member not gonna charge excessive. What, $10 per page?
Just as reasonable.
Just reasonable, like 10 cent, 20 cent, adjust to inflation.
No more 10-cent pages, 50 cents
So
or
you're
whatever.
not obligated to email those documents, you're not obligated to do that.
Yeah,
The other thing it says you have to allow access.
Right.
yes.
Correct. So even if you have someone that lives in Canada or another state, they have to physically come within, is it 40 miles or 50 miles of?
45.
45 miles.
Of the location.
If
Yes.
that is, at the moment, if that is how you set your reasonable rules to access a record,
But we don't have to email.
you don't. So at this moment, the statute only says you have to allow access to records and you can set reasonable.
Yeah, I hear some of the board members, they allow access, and when the unit owner come into that, the board members just show the room that, go look for yourself. So allow access. Don't have to make you have to hand them the access to the record. You allow
Is
access.
the board allowed to require a initial or signature saying, I have, I received, I saw that document? I'm asking because we have someone who will ask again and again.
Yes,
whether she
you
will-
can document it. You can document to see
I
that.
do- Yeah,
But
I
if
use-
she refuses, and she does,
And then you have the rights.
to not give it to her.
Yeah,
no, you have to allow her access. Now, if she doesn't want to sign off that she's seen it, we can. As long as you have the proof that you had correspondence that says, come down on Wednesday at 3 o'clock, please, you can say, please sign in. If it's reasonable, again, that's legal to determine if it's reasonable that you make her sign in before accessing the records, would be for them to discuss. But you just have to allow her access to the records. I would say, sign off on your part that she was here, so if she,
Would a witness help at all?
it can, yeah.
Yeah, you can take
Yes.
picture of the person.
Correct.
Yeah.
yes. Oh, videotape.
Yeah, we did.
Yes.
How will I pay now?
Hold up something, record a video.
You allow a representative,
Yeah.
unless it's a
Before
unit
you
owner
mark it out.
authorized, that representative is authorized by the unit owner. Only certain, yeah. Okay, next, not providing timely access to record. What happens if the association failed to allow an inspection or fail to provide timely access within 10 working days, then the unit owner might file a complaint with the division. DBPR.
Complaint, and the division never did anything.
Really? How long, when was the complaint?
19, 20, 21.
That's a long time.
2020.
Probably that is during the COVID time, so. Yeah. So all the older team, Castle, from a senior from before the 2020 is gone now?
Yeah, so as I said,
What
state of-
after the 10 days, after the fine, after 10 days, that never happened in my case.
that you would have to seek that out legally yourself.
Yeah.
From us, yeah.
So you could do a small claims
Correct,
court
yeah.
that is for condominium.
Correct.
Because I know someone that had to do something like that, and it's $500. Because I was entitled to get $1,000 from my association for 2 different things they didn't come through, but then I took over the board, so I said, all right, case closed.
Okay, website requirements, like I said, right now it's require 150 unit plus unit. But subject to the,
You said that you're gonna change it to 25?
yes,
That's what's written.
that's not in stone. Don't tell anybody that I and Castle said that, because it's not officially in law yet. If you have a chance, you can go to the House Bill 1021, and then they have it available in PDF format. You can read into that. Say there's some of the amendment they changed, they underline it, so they added it. So. Oh, board member recall process. Board member can be recalled either by a vote of a general membership meetings or serving of an agreement in writing by a majority of all voting interests. A special meeting of unit owners may be called by a petition submitted by 10% of the voting interest. If the recall is approved by the majority of all voting interests, by vote of this meeting, the recall will be effective. The board shall duly notice and hold a board meeting within 5 business days of the unit owner meeting. If the board determines that the recall is valid, then the recall becomes effective upon conclusion of the board meeting. The recall board member must turn over to the association any record and property within 10 business days after the vote. If the board fails to duly notice and hold the required meeting, or at the conclusion of the meeting determine the recall is not valid, the unit owner representative might file a petition pursuant to Section 718, 125, challenging the board failure to act or challenging the board determination on its validity within 60 days. The recall board member might challenge the validity of the written agreement, the ballot, file, or the compliance with the procedure requirement of the recall.
So they can be recalled if only 10%
Petition, file petition.
file a petition, that they don't have to do another vote.
Then you have to vote.
10%.
Oh,
Ten.
That's just to get the vote.
Yeah, to get the meeting.
What percentage do we need?
Majority.
Majority. Yes,
50%.
yes.
Is it at the unit owners meeting that you have to have 3 people a minimum, is that what you're saying? Or people have to petition and then all of the unit owners get together,
So
which would include the board members because they're unit owners.
Yes.
you're petitioning for a unit owners meeting, so that's 10%.
Oh, so that's what I was
Gives you the
asking.
unit owners meeting, and then at that meeting, that's when you tell the board, filing for a recall, and then the board has regarded, but, whatever they do, you can then file arbitration and move forward.
But then this board meeting that you have to have 5 business days after, that's a meeting that needs 48 hours posting as
Correct.
well?
Yes, to acknowledge.
Everybody is also able to come to that.
Correct.
How long has that been in effect? This,
Oh.
these time limits?
I've only been here for 2 years, but it's been there for 2 years.
The reason I'm asking, we were not able to take someone off the board unless I'm misunderstanding. Board member recall, is that removing them from the board?
Yes.
Okay, we were not able to remove them from the board, but from their officer's position was all that we could do.
So removing an officer usually just takes a board decision for that. So when you do recall, I do suggest you recall the whole board, because whoever's left is allowed to appoint board members. So they can just reappoint the new person.
This is right after an election.
Yes.
Only.
No,
So you can't do this
you
like
can
a
do
year
this.
late, months later.
Right,
You can do it
within the 60 day of the election, after election.
6 days after the election.
Right, and then you can't, then it's a different procedure after the 60 days have passed.
Yeah, after 60 days, you have to probably wait for the next election.
Yeah.
Yeah, because the annual meeting is every year, right? So the election is every year. Commingling of association funds. The board must not commingle association fund with officer or director private funds, manager or employee private fund, or any other association funds. However, the board may commingle operating and reserve fund for investment purpose only. The funds must be accounted for separate, and the account balance cannot go below the amount required for reserve. Yes, debit cards are not allowed. Debit cards are not allowed. It is prohibited for official, director, employees, or agent to use debit card issued in the name of the association, or have the debit card billed directly to the association for the payment of any expense that the association incur. The use of debit card in the name of or on behalf of an association is punishable as credit card fraud. Credit cards and checks are allowed.
Commingling of a director's funds with another is also punishable by law.
Yes, correct. Unless it's for investment purpose.
Now, and that's the.
Anything is, you do anything that's good for the association, and it's good. For personal interest, is no, right? It's common law. Competitive bid. The association must obtain at least 2 competitive bids for contracts of item, service, or work that will exceed 5% of the total annual budget, including reserve. This does not apply for the following: employee of the association, attorneys, accountants, architects, community association manager, engineering and landscape architects service. No, please note, the association is not obligated to accept the lowest bid. So it's it's a war vote, right?
Was there a time when it was thought that you needed 3 bids?
Yeah, I thought that
So
was
we
already
hear that a lot.
Yeah.
3 bids. We can only read the statute as black and white, and it says bids. So to us, we take it as 2.
Okay.
Unless your bylaws have something else in it that you have to get 3 bids.
I don't know that it says that.
All of
We
the
voted for
assumption
none of
that
that,
you need
but-
just bids.
Even though it's a statute, in the statute, but sometimes check with your bylaws to make sure, see what your bylaws say. Common elements, no charge. association cannot charge unit owner, their tenants, or guests a fee to use the common elements unless it is stated in the governing documents. It is approved by a majority vote of the member of the association, and the charge relate to expense incurred by an owner having exclusive use of the common elements or association property, like using the clubhouse for your own personal party. Like I said earlier, you have to lease that if you have the clubhouse for the party. Yes, and then association can make money, some money. Some association, they have a bingo in their clubhouse. Association directory. Association might publish a unit owner directory for the convenience of the member. A directory might include unit owner names, unit addresses, and phone numbers, and other contact information. A unit owner might opt out of being published in the directory. Multiple phone numbers may be published, and the unit owner might consent to have other contact information published. The association is not liable for the inadvertent disclosure of information that is protected under this section if the information is included in an official record of the association and is voluntarily provided by an owner and not requested by the association. Amendment to bylaws. When amending the bylaws, the board shall follow their governing document procedure. If bylaws do not provide a method of amending take approval of 2/3 of the voting interest. No bylaw shall be revised or amended by the reference to its title or number only. So, like example, proposal to amend existing bylaw must contain the full context of the bylaws to be amended. New words must be inserted and the text underlined, and word to be deleted must be strictened with hyphen. So that's what the Florida legislature they do. They underline the new word and they delete the stricten the hyphen to delete the word. A stop-go letter. The association must respond to requests for an estoppel certificate in 10 business days. An estoppel certificate is effective for 30 days if delivered by hand, or 35 days if mailed. The statute sets maximum rate for estoppel as follows. The maximum rate as base fee for preparing an estoppel is $2.99. However, if you can rush the request or expedite within 3 days, there will be an extra $119. Or if the unit in question is delinquent in pay fund, an extra $179 can be charged. Conflict of interest. It is prohibited for an association to employ or contract a provider of goods or service that owned or operated by a board member or relative unless approved by 2/3 majority vote of the other board member at the board meeting. Disclosure of the conflict of interest must be written on all contract and transactional document with a copy of the agenda where the topic were discussed. The minutes of the meeting shall disclose the conflict of interest. Existence of the conflict of interest must then be disclosed at the next unit owner meetings. Unit owners might avoid the contract at the unit owner meeting upon motion from any member with a majority vote of those present. If conflict of interest transaction occurred without any of the procedure mentioned, then the contract might be voidable and terminates upon the filing of a written notice, terminating the contract with the board of directors, which contain the consent of at least 20% of the voting interest. If the contract is canceled, an association is only liable for the reasonable value of the goods and service provided up to the time of cancellation. Civil and criminal activity. Can civil or criminal penalty be made against board member? Yes. Certain activities are punishable as crime. Forgery of a ballot envelope used in a condominium association election or voting certificate. Theft or embezzlement of the funds belonging to the condominium association. Destruction of any official record of a condominium association in furtherance of the crime is punishable as tampering with evidence or as obstruction of justice. An officer, director, or manager of a condominium association may not accept kickback from any person providing or proposing to provide goods or service to the association. Criminal activity may be provided for accepting kickbacks. However, director, official, or manager may accept items received in connection with trade fair or education programs. Any official or director charged by information or indictment with crime described in Chapter 718, Section 111, subsection 1D, must be removed from the office and the vacancy filled for the remainder of the term or suspension by the election of new officer or director. Electric charging and natural gas station. I don't know if you guys own any electric car, right? Hybrid is hot now. Right? Electric is come down. What Elon Musk's car? Tesla? Unit owner install electric vehicle natural gas station. An association might not restrict a unit owner from installing an electric vehicle charging station or natural gas station within the boundary of their common elements parking area. The installation may not cause irreparable damage to the condominium property, and the association may require the unit owner to comply a list of requirements as stated in the statute. The cost of installing, maintaining, or removing the station must be paid by the unit owner and is responsible for complying with all the federal, state, or local law and regulation. And now, there's some more few slides to go before the end of our presentation. Is our information. Have your phone ready to scan out, take a picture of our QR code. The Florida legislature enacts a new requirement for structural inspection for building 3-story or higher to report to Division Pacific Building Report information on or before January 1st, 2023. So you can go to our website. The email is tcmh building reporting at myfloridalicense.com, or you can mail to the Division of Florida Condominium Timeshare Mobile Homes. Attention, building reporting, 2601 Blairstone Road, Tallahassee, Florida, 32399.
It's a CT.
You can, for instant access to division information and to view some helpful condominium information in our Did You Know gallery or visual information, please feel free to visit our website by scanning the QR code with your mobile phone to the left. If you are a board member and haven't already done so, you may register with our division. All you have to do is scan the QR code on the right. Doing so will add you to the division mailing list. So you will be the first to receive communication on events and presentations similar to today.
This is being recorded, is that correct?
Excuse me?
Is this presentation being recorded?
Yes.
Yeah, on video.
Yeah.
That's what I thought, yeah, okay. So, no, that's great, because maybe you folks can put it up on one of their TV stations, so people can see it.
So Gene, Yuko is recording it and they plan to put it on their CV site.
Yeah, right.
The department has an online system for payment of their annual division fee with accept credit card and electronic check. Scan the QR code to the left to create an online account. If you have any question, you might contact us through our customer contact center at 850-488-1122, or you may make an appointment online for a 30-minute section on our website to visit with our compliance staff to discuss general question, either our Doral, Fort Lauderdale, or Tallahassee compliance office. Scan the QR code to the right. Our online contact also found on myfloridalicense.com/contact us. Didn't work? So probably the communication changed the QR code.
It's working.
We're in the process trying to do is redoing our website and stuff like that. So you can anytime go to myfloridalicense.com and click on regulation and licensing, and then click on condominium, and then you go through.
License, but I don't see where you can add board member names.
Just the URL.
So here's the information for the. You can create an appointment to meet with the ombudsman office in Fort Lauderdale. The information is you can email them at myflorida ombudsman@myfloridalicense.com. The phone number is 954-202-3234.
But that's just reductions.
No. We want to make it on the
Finally, for update information on division event like the one today, please visit our online event calendar. Please scan the QR code. So probably it's not working. So if you have any more questions, we are more than happy to take your question. If you are not,
Yeah, if you guys want to reach us personally, our email is ctmh, so condominiums, timeshares, mobile homes. Sorry. Our email is ctmheducation, education, at myfloridalicense.com. Unfortunately, I ran out of pamphlets at the expo. I thought I had them in my car. Yes?
I have a budget question. My association did not have a budget for 3 years, and yet the property management doesn't inform you what's the increment, but they can go into your account and take it out. And nobody can answer. When I request a budget, I never get it. So I don't pay the new amount. Unless I can see a budget, I'm not paying. No meeting, no budget. Once he sent me a proposed budget, who creates the increment? No answer. And this is what I complain to Tallahassee about, and no, I can't get help.
So what I can say is, you already have a complaint on this. If you want to email us, if you have that case number, I can check where that complaint is. As I mentioned, in 2018, in 2020, they took the decision making out of the hands of the investigators. So investigators can no longer make decisions on what happens with these cases. It's sent up to Tallahassee, and it's decided.
Two is sitting in Tallahassee.
It's decided by the legal team in Tallahassee.
Also, I have 19, 20, 21, 22.
You can, send us an email with those cases. I pass it forward to supervisors, and hopefully that speeds things up for you. That would be the best that I can do in that matter.
But I want to know, how come can the management, because they can go in your bank, can they go in and take out every year?
No, unless you have some sort of direct deposit thing that you set up with them.
They don't have it set up.
Yeah.
I'm a retired banker, and I know that's totally wrong.
Yeah, unless there was something signed over.
But this
that
is
would
what
be the
goes on in the village.
Is that something that maybe the ombudsman could help them with?
No, the ombudsman really only handle election issues with it. That's something criminal, what it sounds like. With that would be the state attorney's office. I could send you information they have a lot of senior help with the state attorney's office. That might be the best option to go by.
I've gone everywhere. I even was abused in front of code enforcement officer. We went to the, I wrote the state attorney Aaron Board, and they just wishy-washy did, and a civil charge, and I couldn't get an answer.
If they didn't properly post and hold notice the annual budget meeting, they cannot foreclose on you for not paying that additional
No,
money.
I paid for the last 3 years, the last amount. I've been paying, but I paid not
I thought this year you were not paying.
I pay every year, but I'm paying the same amount 3 years back.
The old amount.
Right, and if they didn't properly hold their budget meeting and notice it and all that, they cannot,
They already have a lien on my place.
they can't put a lien on you.
They put a lien
They
on my
can't,
place.
because they didn't properly notice the meeting.
Yeah.
That's not an enforceable lien.
You have a lawyer? Oh, yeah.
Hey, so we're gonna wrap up the meeting so we can stop the videotape, and then we'll discuss these other things afterwards. So I want to thank James and Cassio for coming out. We appreciate this, very informative and helpful, and thank you for everybody for attending. Appreciate it.
Thank you.